More Texans come into personal contact with municipal courts than all other Texas courts combined. Whether they are jurors, witnesses, or defendants, the public impression of the entire Texas judicial system is largely dependent upon their experience in municipal court.
Recent state records indicate that there are 877 municipal courts and 1,260 municipal judges. Municipal courts, like Justice of the Peace courts, preside over fine-only criminal cases. Last year, 7,445,864 cases were filed in municipal courts in Texas. Municipal courts held over 3,849 jury trials. Municipal judges issued over 2 million arrest warrants and almost 6,000 search warrants. These numbers are constantly growing. Municipal judges make up 36% of the entire state's judiciary. 47% of municipal judges have attended law school.
There is a tremendous diversity among municipal courts and municipal judges in Texas. Texas municipal courts serve some of America's largest cities and a plethora of classic small Texas towns. They serve populations both huge and very small. They work with police departments numbering in the thousands and serve cities with no police at all. Yet regardless of the city's size, the municipal court is the court the average citizen is most likely to encounter as a defendant or court participant.
This video has been created not only for municipal judges and court support personnel, but also for other members of municipal government and for members of the public who are interested in the role of the municipal court.
The powers of all courts in the United States come from the U.S. and state constitutions. Under the 14th Amendment to the U.S. Constitution, any criminal defendant, including those charged with fine-only offenses, has the right to due process of law that includes a fair and impartial judge.
Both the federal and Texas constitutions call for 3 branches of government. The legislative branch, elected representatives of the people, create laws. The executive branch, presidents, governors, and other executive officers, are elected or appointed to enforce the law and provide executive authority. The most common executive public servant is the peace officer. Finally, the judicial branch, courts, resolve disputes between citizens and stand between the individual and the power of the government.
The concepts of separation of powers and checks and balances appear in both the U.S. and Texas constitutions. Although cities or municipalities may not strictly follow this setup, the constitutional mandate of judicial independence does apply to municipal courts. Neither municipal courts nor municipal ordinances are the product of municipal sovereignty. Municipal courts originate in the Texas Constitution and legislative enactment. The municipal court is a state court, and its judges are controlled by the same rules as all other state judges.
The requirement of an independent judiciary is clearly set forth in the preamble to the Texas Code of Judicial Conduct. It reads, "Our legal system is based on the principle that an independent, fair, and competent judiciary will interpret and apply the laws that govern us." While there is often a temptation for judges or municipal governments to feel a certain ownership of the municipal court, like all courts, is governed by the rule of law by and for the people of the state of Texas.
One of the most common intrusions into the independence of the court is in the imposition of quotas or evaluation of the court based on revenue generation. Section 720.002 of the Texas Transportation Code prohibits the use of citation or income quotas to evaluate, promote, compensate, or discipline an officer or municipal judge. The creation or use of such a plan is grounds for removal of the city official that promulgates it.
The municipal prosecutor represents the executive branch of government in the municipal court. Article 45.201 of the Texas Code of Criminal Procedure provides that all prosecutions in a municipal court shall be conducted by the city attorney or by a deputy city attorney. That section also provides that the county attorney may volunteer to take the role without compensation. Finally, the section goes on to instruct prosecutors that their primary duty is not to convict, but to see that justice is done. All other Texas prosecutors share this same duty. The prosecutor is the representative of the state as an agent of social control, not a local revenue raiser. Thus, the prosecutor's duty is social control by enforcement of criminal law, not creating revenue.
Prosecutors are responsible for deciding what charges to bring, the language used to charge the defendant in a complaint, when to recommend dismissals, when to plea bargain with defendants, when to interview witnesses, what witnesses to call, when to try cases before the court, and what to advise police on how to best proceed in cases brought to that prosecutor.
The judge, on the other hand, plays the part of the impartial judge of facts and law. The municipal judge has three separate kinds of duties: judicial duties, administrative duties, and magistrate duties. In each of these roles, judges have an obligation to remain competent in the law, to not allow outside influence on their discretion, to be fair, to maintain propriety, and to avoid the appearance of impropriety. Judges have great power, and with that power, great responsibility.
Judicial duties include requesting and accepting pleas, making and rendering judgment, setting fines, choosing between legal alternatives, making decisions of law, making decisions of fact in pretrial matters and in trials before the judge, instructing juries, ruling on objections at trial, setting or forfeiting bail, granting or delaying motions, granting and revoking deferred dispositions, and making and executing decisions on fine collection. Judicial duties are all about the difficult job of making decisions in a fair and just way under the rule of law.
Administrative duties are often shared with court clerks and other court support personnel. Such duties must be diligently and promptly discharged as required by the Code of Judicial Conduct. Such duties include management of dockets in order to promptly dispose of cases in the court, guiding the operation of the court and its staff, dealing with financial reports and money, preparing budgets, and coordinating support by warrant officers who serve court documents and warrants. Municipal courts can employ a good number of people, and the day-to-day operations of the court take up much of a judge's time.
All municipal judges are also magistrates under Texas law. Magistrates are required by Texas Code of Criminal Procedure, Article 2.10, to preserve the peace within their jurisdictions by the use of lawful means, to issue all process intended to aid in preventing and suppressing crime, to cause the arrest of offenders by the use of lawful means in order that they may be brought to punishment.
The magistrate must be fair and detached, but does not serve as a referee as much as a quality control officer. The primary duty of the magistrate is to make a fair determination of whether probable cause exists in order to empower police to make searches, arrest, hold persons in custody, or limit defendants' conduct while on bond.
Magistrates may issue warrants for any offenses that occurs in their countywide jurisdiction. This includes felonies and jailable misdemeanors. The officer desiring an arrest warrant must present the magistrate with an affidavit that contains in its four corners probable cause that a particular defendant has committed a specific crime.
Likewise, the magistrate may issue search warrants, also based on affidavits containing probable cause. Municipal courts of record may issue any search warrant. Non-record courts are prohibited from issuing mere evidence warrants. This means they may issue warrants for all kinds of contraband, but not for items that may be seized solely because they are evidence in a crime.
Magistrates may also issue temporary, emergency mental commitments. Here, municipal judges serving as magistrates play a key role in individual and public safety.
Much of a magistrate's time is spent in jails and detention facilities, performing jail arraignments or magistration. Article 15.17 of the Code of Criminal Procedure requires this procedure on all arrests for criminal charges. The hearing must take place without unnecessary delay and in no event more than 48 hours after the person is arrested.
This often requires that the magistrate work at night and on weekends. The magistrate must find probable cause to continue the detention of the defendant for a criminal offense, set or deny bond, warn the defendant of important constitutional rights, and assist the defendant in requesting appointment of counsel where appropriate.
The magistrate may also set conditions on bail, including an interlock device on the ignitions of persons accused of repeated violations of DWI laws.
In cases of family violence, the magistrate may also be called on to issue magistrate's orders of emergency protection. These orders prohibit the family violence defendant from contacting or doing further harm to their alleged victims.
The magistrate also has a continuing duty to provide examining trials to persons they see in jail. This duty exists on the request of the defendant up until the defendant is formally charged with the offense in a court with jurisdiction of the case. An examining trial is an adversary hearing where the prosecutor must establish probable cause in a trial-like setting.
A magistrate may also be called on to give warnings to juvenile offenders before they may give confessions while in police custody. The magistrate must go to a designated juvenile processing office, give the juvenile warnings concerning their constitutional rights, and determine that the juvenile understands their rights and is voluntarily and intelligently waiving them.
Errors by magistrates can result in the suppression of evidence and confessions, release of the defendant, or lawsuits under federal law.
As a magistrate, the municipal judge acts as the front line of the judiciary in the criminal justice system. These duties can make up all or none of the municipal judge's activities.
Although the offenses heard in municipal court are not as likely to get steady press coverage or become best-selling crime novels, they are nonetheless very important to our communities. Imagine a community with no traffic enforcement, where public drunkenness and disorder rule the day, where minor thefts and assaults go unpunished, nuisances run unabated, minors drink and smoke without fear of prosecution. Simply put, municipal courts make our communities better places to live. They are a vital branch of municipal government and the workhorse of the Texas judiciary.
If the experience of citizens in those courts is positive, the image of the municipality and the criminal justice system is enhanced. Our municipal courts should be a symbol of the rule of law for the benefit of the people of the state of Texas.